Hello, hello, hello. It's Tony McGraven coming to you from Chicago. As usual, you know I've been behaving myself because you get early streams. We got some good stuff today. I have to thank Chidaskadam and even more so Rocky Lennon, who sent me all sorts of good stuff. We've got a big interesting sentencing. I think it's in Wisconsin. I've had that judge on before. But before we get there, we got a group of fun little clips. I even I did a video yesterday in Arizona, and everybody got all frustrated. I did a short clip from there too, just so you guys can see Judge Quashing one more time, and a bunch of other stuff. Let's get it started, shall we?
I will accept your plea of guilty. It also alleges you failed to appear to court to answer to that charge. That was on March 13th. Do you wish to admit or deny failing to appear on March 13th to handle this charge?
I didn't show up to that either. I wasn't even late.
I'm sorry, I didn't hear that.
I wasn't even late.
The allegation indicates that this incident took place in Otsego Township of Allegan County in the state of Michigan. Does that sound correct to you?
Yes.
The allegation indicates you attempted to tamper with the vehicle of Kyle Wade. Is that true?
Yes.
What did you do to attempt to tamper with that vehicle?
Threw a bag of carrots at the car or at the vehicle.
Yeah, without getting into further detail, there were drugs involved that people were giving to me that ended up being glue. Like I smoked some glue and stuff. I thought I was smoking crack. And
then Miss Silva?
Yes.
All right, your charge is a Class A misdemeanor assault causing bodily injury, including family violence. The range of punishment for this, if you're found guilty, is a fine not to exceed $4,000 and a jail term not to exceed 1 year or both. Your bail is set at $4,000. Bond conditions are 200 yards stay away from the complaining witness, no contact with the complaining witness, and to participate in a drug evaluation. Do you want a court-appointed lawyer or do you plan to hire a lawyer?
I want a court-appointed lawyer because there's no evidence for it. There's the person that called. She's been torturing me for at least 9 months. So I actually want to take this to trial. But did you say I'm gonna get out today? I'm gonna get out of here one.
Okay, so probably better to not talk about the case. You do get a personal bond, which means you can get released, but you do have those bond conditions.
As usual.
Yeah.
200 yards stay away, no contact.
I can't fix her, but I can make it worse.
Drug evaluation.
I have a question.
Can you comply? Listen, can you comply with that?
Yes, ma'am.
Okay.
That number that's been calling, that number has called this police department around 9 to 10 times. And yes, I want to go to trial for this because I didn't.
Okay.
I want to make this a little bigger because I'm just tired of this person that's been torturing me, calling the cops, saying that I'm crazy.
Well, that's what you'll want to talk to the lawyer about. Okay. And then I need to go over this emergency protection order with you. This is for the protection of Guadalupe Rodriguez.
Yes.
You are prohibited from committing family violence or an assault or any type of stalking or trafficking offense against that person. You're prohibited from communicating directly with her in a threatening or harassing manner or communicating a threat. Oh, it's a male, isn't it? Is it a male? Okay. Communicating a threat to him directly or through someone else. And you're prohibited from having any contact with this person. And then you're prohibited from going within 200 yards of 9614 Carson Creek Boulevard, Del Valle, Texas. You're prohibited from possessing a firearm. And a violation of this emergency protection order could result in a new charge. This is in effect until midnight of June the 13th, 2024. But your bond conditions that I went over are in effect until the case is over or a judge changes them, okay? Which could go beyond that date I just said. And you'll
Ira, shouldn't you be hungover right now?
get a copy of that. All right. Do you promise to appear for your court hearings? And do you understand if you fail to appear, you could end up with the warrant or capias for your arrest? Okay. It looks like you do qualify for a court-appointed lawyer. And then you should be released in the next 4 to 6 hours. Court date will be on your paperwork. Don't miss court. I hope the lawyer will reach out to you, but if not, you can make phone calls to see if you can figure out who the lawyer is, but otherwise show up for court. And then if you need to make a phone call, you can request to do that.
Thank you.
Okay, do you have any questions?
No, that's it.
Okay, all right, thank you.
Absolutely.
Exciting and new.
Did you guys complete your conversation, or do you need more time?
No,
We
Your
were not
Honor.
able to
There's
come
some
to an
way that
agreement.
I could speak.
All right,
I am
hold on.
the son of Arthur John Eddy Jr. The
Wait.
one.
Oh, this is fun. This is just chaotic. We've got we got a couple of pro se's and a tussle over a trailer, and they don't get the drill.
Who
Wait
is
a minute.
coming here to
Wait,
speak
wait. Ms. Royson, don't get on. I got whoever it is that's doing that speaking, you need to let me, as the judge, manage my courtroom. So, Ms. Royson, were you able to come to some sort of a conclusion?
No.
Okay. And Ms. Magmer, it sounds like you have someone else there, even though this is not captioned to include someone else. But I take it you would also agree with Ms. Royson's position that you have not reached a resolution agreeable to both of you?
No, we have not, Your Honor. I've never signed anything. I rent from the Pinecrest community. The owners of the trailer are the rightful heirs, the daughter and son of Mr. Eddy. And that's who is here
Ms.
with me.
Ms. Magmer, I'm not going to be able to go into the merits because we're not having a trial today. So I'm not going to be able to, what we're having is this is a opportunity to see if we're able to get to a resolution. What I'm going to do is set the matter for trial and a pretrial in advance of that. You're going to get notice of this in the mail. It's going to be as soon as possible. I'm saying it as quick. No.
Are we done?
Yes.
Okay, I'm a little confused.
As am I, considering I'm the one who is the owner of the trailer and why we're currently going through this and why I continue to not be heard when Lena Marie Eddy has no claim to the trailer.
Well, you can appear at trial if you wish to present evidence that's admitted, but right now you're not part of this lawsuit, sir.
Okay, well, in our response, we had filed their divorce agreement as ruled in 2020.
Oh, good Lord. It's just so horrible. He's not party to the action. He doesn't understand. You can see it coming all day long. The trailer park residents aren't exactly going to lawyer up. And then you see what happens.
20. That states that she does not have claim or right to the trailer.
Well, again,
he is as other occupants.
It's okay.
All right. Let me explain to you both. We're not trying the case here today. We're trying to see if we have a resolution. Obviously, we don't. We're setting the matter for trial as soon as possible.
Well, I just want to know, how do I have him included as all occupants? He is part of the occupant.
And as an owner of the home. And I'm still trying to figure out why we're going to court when I'm the owner of the home. She has no name, no right to.
Those are both good questions, honestly, from their perspective. They would really, really benefit from, you know, talking to an attorney who could answer them for them. The judge is not their attorney, but that's okay. He is rock solid though. This poor guy dealing with this nonsense.
That's why we are going to court when this should be dropped, as the evidence provided states she does not have any title to this trailer.
She's going to have to make that presentation at trial. And if
Okay,
she doesn't have that presentation, obviously she's going to lose, right? So there we go.
So,
you can leave the court. Thank you.
Thank you, Your Honor.
You're welcome.
okay, we will. I guess
We're done then, right?
I believe so.
You are done.
All right, then, sir, wait for notice in the mail when the pre-trial will be.
Well, we're going to be sending it out forthwith. It'll be as soon as possible.
Okay, thank you very much, Your Honor. You have a great day.
You too.
Oh man, I gotta get together.
Joseph Fan.
Okay, here we have some epic. I think this is Joskadam sent this to me. This is just some epic self-snitching. Unbelievable.
Yes, sir. Mr. Fan, good morning. You're here because you're part of one kind of DUI. Mr. Fan, I did a driving record search because I wanted to know if you had any prior DUIs, and I thought, well, surely there's only one Joseph Fan in Florida, and I was wrong. There's about 10 Joseph Fans in Florida. Is that a pretty common name where you come from?
No, I go by Shedley, first and foremost. Most of my friends know me by Shedley. Shedley.
Okay.
Shedley.
Okay. Well, you're accused of one count of DUI. There is probable cause. I looked at the criminal.
The judge just retreated. He's like, sorry I asked. Let's carry on with the proceedings, shall we?
History in the driving record. I don't see any priors. So I want to make sure that's correct. Have you ever been charged with a crime before, sir?
That's correct. No.
Okay, that's great. And where do you live?
I live in I sleep in my car. I do DoorDash sometimes. I was sleeping at a hotel, I think a day ago. And Wenham in Altamonte Springs. I came over to I made a trip to my friend Nixon's house. He's
I'm afraid you're about to get into the charge itself. I don't want you to say anything that's going to hurt you, so don't talk about the charge itself. Ms. Jeffcoat and Ms. Simpson,
Here's what I would describe as intermittently but mostly homeless.
Open this case up because this case, it's very unusual, Ms. Jeffcoat, Ms. Simpson. So let me kind of tell you my concern. So at 4:50 a.m., the officer was dispatched to a possible traffic crash on I-10. He gets there. Mr. Fan's allegedly in the car, odor of marijuana coming from the vehicle and so forth. But the complaint says, I asked Mr. Fan when he had crashed, and he showed me messages on his phone where he had sent pictures of the wrecked car around 10:30 p.m. 6.5 hours earlier. Ms. Simpson and Ms. Jeffcoat, as you both know, DUI has to do with the time of the driving, not the time they find you in the car. So I'm going to find probable cause because of the filter body exercises and so forth. I was planning on giving Mr. Fan a conditional release unless something else came up. The problem is he doesn't have a residence. So I can't really give him a conditional release. Mr. Fan, you do not have a residence. Is that correct?
Not as of now. No, sir.
Mr. Fan, do you have the ability to post a $250 cash bond?
Yeah, you can post it, please. Please.
You can post can you post a $250 cash bond?
If you show me how, I will.
Do you have $250 cash?
No, sir.
Okay. Can you get $250 cash?
Yes, sir. If I could speak to someone.
Okay. So Ms. Simpson and Ms. Jeffcoat, I very well may do the same thing I did with the other individual who had no residence, and that set that bond. Ms. Simpson, any additional suggestions here? I mean, it's close to no probable cause, but I think I'm going to find probable cause because of the filter body exercises. But the 6-hour delay is going to be a problem for the state regardless. Let me ask.
Okay, the state has no case here, and the judge knows it, except when he provides them pictures of for the time of the crash. We all know he was driving high. There is absolutely zero doubt about it. He just needed to shut up. Oh, God. I still don't. He now needs to get an attorney. An attorney can get this thing dismissed. We all know. It reminds me of a case I did. I can't remember what it was. It was in front of Judge Washington. I'll put a link to it in the description below. But there was a whole trial. Everyone knew she was driving drunk. Everyone knew she was driving drunk. But they couldn't, the state couldn't prove the elements beyond a reasonable doubt. And that is the problem they've got here in spades. But if this guy's, unless this guy gets an attorney, he's getting rung up for DUI.
Ms. Jeffcoat first. Ms. Jeffcoat, what's your thoughts?
Your Honor, I don't have any additional information at this time. I don't have an objection to the bond that the court is proposing.
Have you ever prosecuted, Ms. Jeffcoat, or successfully prosecuted a DUI with a 6-hour delay between the time of driving and the time the officer responds?
So it's actual physical control. I don't know enough about what was going on when the officer. I don't know if the car was still
in actual physical control. Arguably, the officer could use the time that he got there if the defendant was still in physical control then.
Correct, okay. And the car was.
I follow that logic. I think that if the car was operable, I think that's the case law does say that if the car is operable. Okay, Ms. Simpson, any input, ma'am?
That would have been my top same input, Your Honor. It's about if the car was operable or anything, but $250.
I think that's the issue. So thank you. So Mr. Fan, you've got a $250 cash only bond. You will get to use the phone, sir, in a few minutes to try to post the bond. If you post the bond, you'll be released. Your bond does have a condition. Well, it's not an alcohol DUI, so I can't put a no alcohol condition. I'm not going to put a no alcohol condition in there. So it'll just be the standard terms of any bond, which is no new charges and don't miss any court dates. Mr. Fan, you will get to use the phone right after first appearance to contact friends or family for purposes of posting the bond. If you post the bond, you'll be released. If you're not able to post the bond, Mr. Fan, what I'm going to do is suggest that you, the jail bring you back up to first appearance tomorrow to see Judge Peel. So if you don't post the bond, you'll see Judge Peel tomorrow. If you post the bond, you'll be out. Madam Jailer, I know that some bondsmen will put addresses on there for defendants and some will not. This is one that the bondsman's got to put an address on there for Mr. Fan because the clerk will not have an address to notify him at if they don't. So Mr. Fan, make sure the clerk of court has an address for you if you do post bond. Mr. Fan, do you have any questions?
No, sir.
All right, sir. Wish you the best. Madam Jailer, anything else in Washington County?
No, sir.
Thank you, ma'am. We'll see you next time.
Yes, sir. All right.
Ms. Shepard, I think that's everything that I had. Anything else from the state attorney's office?
Nothing further, Your Honor.
Thank you. Ms. Sampson, anything else from the PD's office?
No, sir.
Thank you, ladies. Hope you enjoy the rest of your weekend. It is 8:27 and we're through with first appearances and court's adjourned.
All right. Do you have a middle name, ma'am?
Michelle?
Looks like you had a warrant for your arrest at a Marana Municipal Court. It was for a criminal trespass in a 3rd degree. The alleged incident date was from October 26th of 2020. I'm going to quash the warrant. Ma'am, you've got to show up in court. This case will never go away until you appear in court. Do you understand?
Yeah.
I'll release you. Your next court date's in Marana City Court, May 13th at 10 a.m. If you don't appear...
Good thing. Quash that warrant. Let her go because she looks like she's learned her lesson.
A warrant will issue. You also had a warrant for your arrest at a city court, a drug paraphernalia criminal trespass from October 19th of 2023. I'm going to quash the warrant. I'm going to release you, give you a chance to appear on your own, May 15th, 2024 at 2:00 p.m. You'll get copies of your paperwork so you can remember those dates. Thank you, ma'am.
Thank you.
What is your full name, please?
Gerald Douglas Mead.
Mr. Mead, you're charged with domestic violence assault, domestic violence disorderly conduct, and 1 count of disorderly conduct. I'm going to enter pleas of not guilty. There is a victim who wants to be heard on this case. The victim on this case, you want to unmute yourself?
Oh.
You want to make a statement regarding release or no release?
Hello. Yes.
Go ahead.
Yes, ma'am. I'm sorry, I'm outside, so it's a little loud. I just want to say that it was a big misunderstanding. It wasn't even involving me and my husband. It was involving somebody else that was taking advantage of us. So I was just trying to say to my husband, and it was just a big misunderstanding. It wasn't even like.
I'm just asking if you have a position regarding release or no release.
Oh, release, please. He has to go to work tomorrow.
I mean, it doesn't matter. I'm releasing him either way, but I just want to know what your position is.
All right, Mr. Mead, I'm going to allow you to be released on your own recognizance. Do not commit any further acts of domestic violence. I believe there was a witness who witnessed your behavior, so you cannot be picking up new charges. Your next court date's in Justice Court, May 13, 2024 at 10:30 a.m. If you don't appear, a warrant will issue for your arrest. You are excused. Thank you.
Thank you, ma'am.
What is your full name, please?
Selena.
What?
What is your full name at the jail? Whoever's talking, please mute yourself. At the jail?
Selena Villarosas.
You are charged with 1 count of shoplifting drug paraphernalia from February 19th of 2024. This case is pending in Oro Valley Town Court. Ma'am, there was a warrant issued for your arrest. You have to show up for court. If you don't show up, another warrant's going to issue for your arrest, and that'll continue to happen as long as you don't appear in court. I'm going to quash the warrant, release you. I don't know. I don't have any information about this. Oh, it's a shoplifting. So don't go back to the store location. Your next court date is going to be in Oro Valley, May 8th, 2024 at 10:30 a.m. Make sure you appear. If you don't, a warrant will issue for your arrest. And then you picked up a new drug paraphernalia charge from April 13th of 2024. And then you had a warrant for your arrest out of city court for a domestic violence assault case from October 19th of 2023. I'm going to quash the warrants, Ms. Rosa.
Yeah, those are the kinds of things that would make you think she's not going to show up. I'm just saying, you know, I've never done this. I'm effectively a layman on this point, but it appears to me that those would be reasons to, you know, sit a bond.
I give you a chance to appear on your own in city court, May 20th, 2024 at 9:30 a.m. If you don't appear, more warrants will issue for your arrest. You are excused. Thank you.
Thank you so much. God bless you.
Holy wow. That's messed up.
Okay, here's the main event. Buckle up. This gets a little spicy.
We will go on the record in the matter 22 CF 224, State of Wisconsin versus Jacob Ritchie. The state appears through Assistant District Attorney Kevin Schmidt in person. We have Mr. Ritchie in person with his counsel, Daniel Chapman. We're set here today in this matter for the sentencing portion of the case. Mr. Ritchie pled guilty to stalking and felony. On January 4th, 2024, the court ordered a pre-sentence investigation report. The court has reviewed the report, and I did not find any material alterations or corrections that jumped out in front of me. Ms. Bauer, victims' rights compliance?
Yes, Your Honor.
All right, Mr. Schmidt, did you receive a copy of the pre-sentence investigation report?
I did. I don't have any corrections.
Mr. Chapman, did you receive a copy of the PSI and did you discuss it thoroughly with your client?
I did, Your Honor, to both.
Mr. Ritchie, you've had an opportunity to go over that document with your attorney?
Yes, Your Honor.
Did you notice any corrections or modifications that I should be aware of?
No, I did not. Not that I'm aware of. One thing specifically jumped out at me, Judge, on page 34 in the second paragraph. Mr. Ritchie was driving a vehicle while under the influence of alcohol, failed to stop for law enforcement, and was verbally resistive to officers. The implication definitely seems to be that Mr. Ritchie was intoxicated at the time he was arrested. Clearly he wasn't. He has 5 priors. There's no way the officer would have let that slip. If the agent is implying he must have been drunk at the time the offense was committed, that's quite an implication to state without further elaboration. Furthermore, later on the on the previous page, page 33, the agent, probably more opinion than fact, but trying to claim that this is not a treatment program is useless credentialism. Of course it is.
Right. Anything further, Mr. Chapman?
No, Your Honor.
Okay, Mr. Schmidt. Well, first, Ms. Bauer, was there going to be any victim statements made here today?
No, Your Honor.
And I don't recall if there was a statement made.
It was a bold
There
move.
wasn't one filed, Judge.
I did not believe that there was, that I reviewed any. All right. Mr. Schmidt, argument and sentencing recommendation, please.
The objection was to the part of DOC saying he was intoxicated during the present offense?
Yes. No, at the time he was arrested.
Saying that he was driving while under the influence, yet he wasn't arrested for an OWI or similar.
I don't know why he wasn't arrested for an OWI at the time, but it appears you'll see here that he was in fact intoxicated.
No, I'm just reading his version where he says he drank a 12-pack.
There's that.
Thank you. The state's going to be joining in the DOC's recommendation. They recommended 1.5 in, 2 out. The main reason the state's joining in DOC's recommendation is it's simply too dangerous with this fact pattern and this criminal history for Mr. Ritchie to be treated in the community. That's why I think Mr. Ritchie should not be placed on probation today. What we see from Mr. Ritchie's criminal history is he has had a lot of substance abuse related offenses. We look him going all the way up to OWI 5 or 6. In his recitation of his version of his past criminal history, he relates to substance abuse all throughout each of those offenses. They all start with something like, they start with drinking or using drugs or something like that. This case, the same explanation is given. It says in defendant's version of events that he said he was under the influence. He says he doesn't remember going into the house because he blames methamphetamine for that. He talks about doing a 12-pack the day where he panicked with the police behind him. I believe that's on page 5, where Mr. Ritchie reported he was intoxicated and in a blackout state the night before he was arrested. The day he was arrested, he stated he had gotten a 12-pack of beer and drank it early in the day, but does not remember anything until he woke up on the couch and believed he was sober. He then got into his truck and began driving to his mother's house. So the fact that, yeah, he's saying he was sober at the time of driving, but the whole, I just drank a 12-pack, woke up, and then started driving. With that history of the OWI, it really shows a lack of insight into actual sobriety and keeping steps like that. When we talk about substance abuse in the context of crimes, we look at it in a couple different ways. A lot of times it comes up, when we have a young offender who doesn't have a lot of criminal history, or they get streaky criminal history. We look at the substance abuse and we say, hey, this is something treatable. Rehabilitation is the goal. Let's talk about probation. I think in a case like this, I'm opposed to that kind of thinking for 2 reasons. One, when we look at the criminal history and we see he's done a lot of treatment, and there's so much relapse, there's so much failure of treatment, that lowers the likelihood that we should think treatment will be successful this time, even if he's doing well right now. Because if the history is, hey, he's done good at some points in the past and then relapse, and again and again and again and again, and here we are again today where he's saying blackout methamphetamine, pounding 12 packs the night before, that's a big concern where, you know, substance abuse is incredibly difficult to treat. And when we see someone who's had unsuccessful treatment of it for 20 plus years, that's a big concern about treatment in the community being appropriate. And two, quite frankly, it's due to the offense. Stalking. What stalking is someone engaging in a pattern of behavior that causes someone else either serious emotional distress or fear of bodily injury or death to themselves or family member or whatnot. The actual stalking behavior here with the house, and it appears very sexually motivated with it. That's why DOC did like the sexual history part, even though this is not a conviction for a sex offense. And the victim is absolutely terrified of Mr. Ritchie, and for good reason. He went into her home. She believes, because of the array of her underwear and the locations of the lotion bottles, that he was masturbating onto her underwear in the house. And that raises great fear of what would happen if I were home? What will happen if nothing happens in the future? Is he going to keep coming in there? She related to it was related in the DOC packet that she had been complaining of this behavior from the defendant going back years. The defendant apparently according to her, gets extremely sexual as a result of using methamphetamine, which is his addiction. So that's a big reason why the state is deeply concerned about treatment in the community for Mr. Ritchie, because the difference of him relapsing or not, may not just be he loses his job or he gets set back on steps or something like that. It may put the victim at risk here. If he gets into states when he's using that he's blacking out and putting people at risk or great fear, that's a huge public safety problem that needs to be addressed. I do appreciate that it's been many years since Mr. Ritchie's last criminal offense. That's something very positive. But the fact that the offense that happens this time since the last time is again related to substance abuse and relapse, that's what raises the big red flag for the state. That's why we're asking for the sentence to actually be imposed today. I think nobody disagrees Mr. Ritchie needs treatment. I think the disagreement will squarely be whether it needs to be in a confined setting or not. And those are the reasons I think it needs to be in a confined setting.
So,
thank you.
Mr. Schmidt,
Well,
you don't think that if
it
he's
done
placed
got
on
worse.
supervision that the drinking of alcohol or the using of illegal substances can be supervised?
I think they have mechanisms to watch that, but Judge, a DOC agent's not handcuffed to a person. A person absconding after relapsing is just, you just do it. And the best they can do is a warrant. Given the nature of this offense, that's why I'm so concerned, as well as the history of failure in the past with treatment.
Or wouldn't you say that, especially based upon this conviction and this conduct, as well as some that's indicated and stated in the PSI from previous, that perhaps a different focus on types of treatment, not just alcohol and drugs, but perhaps sexual addiction treatment and or programming, that could be achieved outside of a confined, contained setting?
Problem with that is DOC didn't really note anything in the sexual history that was a red flag. And the defendant's version of this is, I don't remember doing it because of my methamphetamine addiction, which
ever basically pulled anything out. So you can talk with your attorney about that.
Yeah, ma'am. Well, I never exposed myself.
Amphetamine, not to, hey, he's a sex offender, he's something like that. There's something odd here with this offense that's totally different than the past ones. There is no past sex convictions.
No, but there is a recited history, at least from the victim's perspective, that this has taken place over the course of many years. And even if you listen to what the defendant said about the version of events, it came out when he was under the influence. Correct? Yes?
And the victim also related it to the methamphetamine use.
All right. Okay. Anything further, Mr. Schmidt?
No.
Mr. Chapman?
Judge, I have some issues with this pre-sentence investigation report. It doesn't read like other pre-sentence investigation reports I've read, and some of the biases, and I don't use that word lightly, the biases of the agent definitely come out in areas such as refusing to even admit that the Mission Bible Training Center is a quote unquote treatment program because it hasn't been certified by the state of Wisconsin. I think the elephant in the room here is that everyone is creeped out by the nature of the offense. But when we look at it objectively, as far as stalking goes, there is no threat of harm.
Yes, we are objectively creeped out.
Was no sexual contact. This is a man who got drunk, did something he regrets. Now, I tend to agree there may be something
the old knucklehead defense. He got drunk, he did something he regrets. Haven't we all gotten drunk and done something we regretted?
Psychological that counseling could get to the bottom of as to why Mr. Ritchie, when he gets drunk, acts inappropriate toward his stepsister. He's not doing sister-in-law, I'm sorry. He's not doing this to other members of the public. He's not getting drunk and groping women in a bar. He's not getting drunk and hitting on women on the street. This is a history of Mr. Ritchie acting inappropriate to one particular family member.
Yeah, that's enough. In fact, that's an aggravating circumstance. He's also not hijacking airplanes or committing murder. But what he is doing is pretty bad.
And maybe there is some history there that he needs to get to the bottom with counseling, and it's not just a matter of alcohol. I don't know. I'm not that counselor. But I look at this history, Judge, and first of all, no convictions since 2011. OWI 1 through 5, thefts of motor vehicles, which were taking vehicles from treatment centers that he's at and driving off the facility to get alcohol and then coming back with the same vehicle. There's no history of sexual misconduct whatsoever.
Wait, they say that like it's a bad thing. You're not allowed to leave the treatment center for for a run to the liquor store. What's this world coming to?
I see this as obviously a treatment issue and not an imprisonment issue. It's very clear that Mr. Ritchie understands the need to get to the bottom of this. He's taken steps on his own. And while the agent somehow manages to draw this into a negative that he's been to so much treatment, I would note that since being on probation for his last offense, all of this has been voluntary. This has been Mr. Ritchie voluntarily seeking help for his issues because he understands that he can't keep doing this. He's failed repeatedly. And yes, that is a sign, like failure in the past is likely failure in the future, but failure is also part of progress. I see the agent saying, oh, he needs treatment in a confined setting. Okay.
Interesting failure cuts both ways argument there, counsel. Okay, I'm having fun. He's doing a nice job with the facts he has.
Okay, right. What treatment is he going to get for any of this in the state prison system for a year and a half? He's going to go to Dodge. He's going to sit there for 6 months. Then they're going to staff him. Then they're going to send him somewhere else. He's not even eligible for the earned release or challenge incarceration program, according to the agent. So what exactly does she expect is going to happen? If he needs further treatment from a credentialed Wisconsin treatment facility and a licensed treatment provider, the agent can definitely recommend that. They're not going to. We all know it. The agent is going to say, good job, stay sober. And then if he relapses again, that's when they will recommend an actual treatment provider. Now, in this case, the Mission Bible Training Center is what is working. Mr. Ritchie has been sober and he hasn't had any contact with his sister-in-law in a very long time. He understands the seriousness of what he did. He's embarrassed by it. But this isn't the agent draws 6 years of phone calls. Okay, yeah, none of them involved calling the police, but yeah, when the police are called, they ask, what's the history here? And his sister-in-law says, well, this has been going on for several years. That doesn't
there have been some awkward Thanksgivings over there.
Doesn't mean he's had a stalking conviction every year for the last 6 years. That's what stalking is. It's a pattern of behavior. In this case, none of it led up to police contact until now. But now that we're here, Mr. Ritchie has been taking appropriate steps to address his behavior. And under Wisconsin law, the only reason we should be considering a prison sentence, he's not going to get treatment in the facility. The protection of the public is one person that he hasn't been having contact with. And Mr. Ritchie's rehabilitative potential, I don't think he's a sex offender. I think he's a drug user and an alcoholic that occasionally does inappropriate things when he's drunk. He's trying to fix that. That is rehabilitative potential. Judge, I think this is clearly a probation case, and I am confused by the PSI's recommendation of prison and more confused by the district attorney's recommendation of prison. I understand the risk here, but the risk is substance abuse, which is consistently addressed on probation. The only reason why we're talking about prison in this case is because people are creeped out by the behavior. And I don't disagree. The victim should be scared. Somebody came into her house and did something that is extremely offensive and invasive. But
our world frightens and confuses me. My primitive mind can't grasp these concepts.
Threat of violence and no physical contact. I don't think she's in physical danger. I think this case calls for probation. The probation department will supervise him because this case does involve sexual deviancy at the highest level. They will maintain the no contact provisions and sobriety. And if there's a violation, well, then we could be talking about prison. But that shouldn't come up front, Judge.
All right, thank you. At one time, Mr. Ritchie made a statement, and it's kind of supported in the letter that, yes, I've reviewed the information that is on my bench right here from Mission Bible Training Center about a desire or a potential possible intention to stay in Michigan. Can you answer that?
He still wants to. In fact, wants to sign on to stay there for another 5 months, was it?
Currently, I'm enrolled in their staff training program, which is a 6-month commitment, and I'm halfway through that. And then I think the next commitment after the 6 month staff training is 1 year as graduate staff. And that's when a person will go through the office and become like the program overseer. And so that was what I was signed up for, was to do that, and then that other year possibly.
And that would take place in Michigan?
That would be Gastra, Michigan, which is in Iron County, Michigan.
And from the PSI, I was given information that you were married, you have 4 kids, you have 1 on the way. So would you have the desire and intention to move your family?
Well, we've been praying on that. We've been talking about that as a married couple, that if the door opens up for my family to move, she would be willing to do like a couple-month trial period to see how the.
Oh, sweet Jesus! What?
We would probably move to Iron River, Michigan, which is 5 miles from the mission, which is it's a big support for me. And I had kind of looked around for work. There's a scrapyard that had mentioned that once I graduate the mission to fill out an application, he'd be glad to hire me. So there is a chance for a new start over there. So, but yeah, at this point, we wanted to concentrate on me getting better and then bringing the family back together when that opportunity presented itself. So, and they've been very supportive. She comes and visits me like once a month with my children. And so that's been going good. They have an apartment on the facility that allows families to come and stay and visit for family restoration. And that's been a big part of our restoration that's happened. And as far as Mary having a baby, she's due to go on Monday to get induced. That's coming, this coming Monday. So that'll be our 5th child.
All right, and I'm sure that what you're learning at Mission Bible Training Center, perhaps they're speaking about addictions, are they?
Well, it's more than addiction. It's getting to the root of our problems and depending on God to restore our hearts.
Does it involve actual mental health therapy?
Well, not. It has done a lot of good for my mental health. They teach us how to. They teach us a good work ethic because we work while we're there.
Okay, that'd be a no.
Within the facility. But a lot of my mental health restoration started happening when I started to minister to new people coming in and sharing my life controlling problems with them and how I'm overcoming them. And that's done a lot of good for my mental health for sure. But as far as a psychiatrist goes or any of that, anytime anybody needs that type of help there, we have a Spires in town in Iron River that we bring people to or set up appointments that way through the community around the mission. And the community is really supportive too of people coming in. So.
All right, anything else you want me to know or to consider before I decide what to do?
I trust your judgment, Your Honor.
Well, it's a good thing 'cause you have no choice.
It's been a pretty long road, and I am very embarrassed by my actions. And my fate's in your hands, Your Honor.
All right, thank you. I have reviewed the pre-sentence investigation report. I have heard the arguments of both counsel. I've now heard your position and statement, Mr. Ritchie. I've read the pre-sentence investigation report, and it does note that the victim here has sought out and has been granted at minimum a 4-year injunction or restraining order against you. Therefore, there is to be no contact. Violating that means there could be additional criminal charges filed against you and additional criminal convictions. Plain and simple, I think it has been stated by both sides. This is creepy. It's scary. It's gross. It's not legal, and it could be dangerous.
Understand.
And the fact that this did occur over a span of years and that victim was the one targeted when you were under the influence brings about this conviction, the stalking conviction. And the victim, rightfully so, is scared of you. It is not only did you break into her home, take her things, use her things in a very creepy and weird way, but you violated peace and tranquility and privacy and all of those things that a person's home is supposed to provide. And on top of that, you're supposed to be family.
I know.
Even though she's a sister-in-law, it's still a family unit. So that raises the level here.
Judge, he just wants to convert her to a sister wife. I don't see the problem here.
Here a bit. Now, I've looked at the matter and it is serious in all respects because of all of those facts of the incident. Now, if I look at you and your character and your past criminal record, you have a criminal record. It was laid out by both counsel, and that a lot of it involves you being under the influence, you being an addict. You're addicted to drugs, you're addicted to alcohol, you are an addict. And quite frankly, in my review of the criminal complaint, as well as the information provided in the pre-sentence investigation report, a lot of it leads me to believe that you are a sex addict as well. That you have those inclinations within you, and that they are released or let out when your inhibitions are lowered, when you are under the influence of any type of intoxicant, such as here, where you did report that you remember or could recall drinking a 12-pack of beer, but you don't recall much or anything after that. And I believe you had said something about taking marijuana a few days before the incident, not marijuana, methamphetamine, a few days before that incident. Who knows if after you consumed all of the beer that you didn't use meth then? Nobody knows, because you are the best person to know exactly what happened that day, but you can't recall because you consumed too many intoxicants.
Oh, he knows and he remembers. I don't buy this for 1 second.
And then you engaged in activity that was unlawful. I have to look at needing to protect the public, and here, most importantly, I have to look at protecting the victim, because all of this has been directed towards this individual. But it's not to say that the community at a large could not or may not be affected or need to be protected as well. Because if you're not able to do what you need to do, you're not able to get the services, you're not able to put your life back in place and to push out the demons and to take control of your life and your actions, if you're not able to do that, who knows? And that's the question. And so I have two complete opposite recommendations here. One from the state, both from the state of Wisconsin and the Department of Corrections, that says this is a prison sentence now. He must go to prison now because it is that serious. And then I have your attorney and defense saying, Judge, you've got to look at this case. You got to look at him in particular, his history, all of these things, and look at the fact of whether or not he can get the help he needs outside of confinement. Higher courts have told me that I must look at probation unless I need to protect the public from further criminal activity from you. If there's no other less means to do so other than incarceration, unless you can only get treatment in a confined setting, being incarcerated, or if I put you on probation, that it would unduly depreciate the seriousness of the offense. This is a very serious matter. Again, it is creepy. It's creepy, it's weird, it's scary. Nobody wants to be put in that type of position, but is this something that you cannot find treatment and or services outside of confinement? That's the issue here. I tend to agree with Mr. Chapman that I don't think you're going to be able to get the treatment you absolutely need in prison. You can get substance abuse treatment, you can go through other types of programs, but I don't think you're going to get what you need. And I truly believe, based upon the facts of this underlying case, as well as the information contained in the pre-sentence investigation report, you need at least at minimum to be evaluated for sexual addiction, to be evaluated, to go through the treatment, the programming, and the therapy, on top of the substance abuse treatment, the alcohol, the illegal substances. If you're able to do that and you're able to succeed, then you're able to rehabilitate, then the public is able to be protected. And so you have your work cut out for you, and you're a father of almost 5 children. You don't have the pleasure and privilege to think about you and your needs and your wants, and not to put the focus on your children, okay? Because they need 2 parents that are going to be there to support them financially, emotionally, physically, mentally, all of those ways. 1 children is hard. 2 is even harder. 3 is a whole lot of work. 4
A child is difficult too.
is enormous. 5 is going to be exponentially harder.
Yeah.
And to think that all of that would be placed upon your wife's shoulders, innocent shoulders. She's a victim too for your actions. Your children are victims too for your actions and your choices. This is a hard one.
See what you did there.
Because this is so scary in the thought of what could have happened if the victim were present, what could have happened if anyone else had been there, especially considering you don't recall the events of the day because you were so under the influence. With regards to this matter, I believe that first and foremost, the victim does need to be protected. But I need to know, Mr. Chapman, he sat some time in jail, but I'm not certain how.
I think only
how
2
much.
days credit, Judge. He sat overnight.
Only 2 days of credit? Okay. This type of conduct and action does involve punishment. It needs to have punishment. Now, is there, do you have things that you need to fix, you need to cure, you can rehabilitate? Yes, but there needs to be some form of punishment to deter you, to deter others from doing anything like this. Conditions, whether on extended supervision or any probation, would be no contact with the victim or victim's family, immediate family, no contact at her place of employment or her residence, absolute sobriety, no use or possession of any illegal drugs, substances, or paraphernalia, no alcohol. No going into any establishments that have the primary purpose for the sale or the service of alcohol. No casinos. That means no gambling. Gainful employment. A sexual addiction evaluation, and to follow all recommendations. Sexual addiction and AODA therapy and programming, and following all recommendations. As much as I mean, it's obvious I'm a woman. That's hard to be distracted there from that. But I can't act as a person who would be in that position and respond emotionally as to this type of action. It's disgusting. But I do believe that people are able to rehabilitate, and I don't see this in your history. I see you were an addict, plain and simple, in many different ways. And when one person is an addict of one thing, it's fair to say that they have the disposition to become addicted to other things. And that to have other addictions come out when they are in the process of doing things related to one of the addictions. I'm going to sentence you to 1.5 years of initial confinement, 2 years of extended supervision. I am going to stay that and I'm going to place you on probation for the period of 3 years. I am going to order that as punishment, you must sit 9 months of incarceration in the local jail as conditional jail time. Because there has to be a punishment for this type of behavior. It was beyond wrong and creepy and disgusting. And the fact that not only the incident alone, but you went into somebody else's home. You violated their privacy, their freedom, their peace, and the quality of life that they should be able to expect. I'm going to give you 45 days to be able to report to jail. You sit your time. If I did not do conditional jail, I do believe then the conduct and the crime would unduly be depreciated if I simply placed you on probation.
I understand.
You have 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. I'm ordering you to provide your DNA. You must provide that to the sheriff's department. 2 days of jail credit.
Oh, no problem. He loves doing that.
You must undergo the sexual addiction evaluation within 45 days of your release from the conditional jail. 45 days. I'm going to assess $518 in fines and fees. Well, I'm only going to assess 500 because it looks like we have $500 cash. I don't know how much cash do we have.
I think it was $500, Judge.
This is court appointed though, correct?
It is, Your Honor.
Do you have your bill? Or
No,
an
no.
idea?
No.
What I'm going to do is I am going to assess $518 in fines and fees. You have 500 posted, but it will first go to pay your attorney's fees and then it will go to your fines and fees. Is that correct? Is that good with you?
Thanks. Yes.
Okay.
Actually, has 574 and 0.70 in bond and 500 in attorney fees.
Okay. So it might be taken care of. It might not. It all depends on what Mr. Chapman's final bill is, but you have approximately $1,000 in.
Okay. Thank you. Close.
I said DNA, you need to provide that. You need to go to probation immediately and get it set up. And then again, you need to report within 45 days to serve your conditional jail.
Thank you, Your Honor.
2 days of jail credit. Mr. Schmidt, what am I missing?
Nothing from me.
Mr. Chapman,
I'm not even sure what the current policy is regarding Huber and Burnett County, but is he allowed work release privileges on the conditional jail time?
I have no idea what conditional jail means. I have the same exact question. If anybody in the chat knows, tell us. I don't know what they mean by conditional jail.
do not have Huber, so no.
And you say a sex addiction assessment. Do you mean a psychosexual assessment or something more specific?
They have sexual addiction evaluations and assessments through some therapists and things, sexual addiction therapists.
Okay, I just wanted to know specifically so the DOC knew what they were supposed to be getting. I didn't want them to get the wrong assessment, so that was all.
No firearms for life, no voting in any elections until your civil rights are restored. The court is also going to order as a condition, since this is, I understand what the DOC is saying.
That makes sense as a condition of probation. So I think he has to serve 9 months in jail as a condition of his probation, as opposed to going to prison.
The mission Bible training not necessarily being treatment. I see what defense is saying where it is or can be treatment. It's just a different type of treatment. So I'm going to order an AODA assessment and follow through and do any substance abuse alcohol treatment as directed by your agent. Okay? Because that needs to be focused on too. Body, mind, soul. Right now you're working on mind. You are working on body, mind, and soul with the mission. However, you need to look at the addictions and trace those as well in that different respect with treatment. Anything further?
Can I just ask that he be authorized for work release privileges, not house arrest, but in and out of the jail, if the jail gets finished and they eventually start doing that within 9 months or 10 months, I guess? I think their new jail should be done before he's released, shouldn't it?
Yeah, but I don't think they're having Huber.
Really? Okay.
So it can be motioned at a later date in time if in fact that is an available thing.
And I assume the court, if he gets revoked, Huber would be appropriate if it exists then.
He would what?
If he gets revoked after probation, that Huber would be appropriate then, if it exists.
If it
State
exists.
prison sentence.
If he is revoked and he's sent to prison, and what Mr. Schmidt was saying is,
You're right. I'm done.
yeah, so it wouldn't matter. But if he is revoked and he
That's
is
the way I
sent
see
to
it.
prison, he would not be eligible for challenge incarceration
Right.
programming. I believe he would still be able to do substance abuse.
I think stalking is a statutory ineligible. That's
Okay,
why
so
he's
he
not.
would not be eligible for either then. All right.
Correct.
Okay, thank you. We are adjourned.
Well, there you have it. I'm not sure. All good questions in the chat. I'm not sure that, although, so I'm just talking off the top of my head. I don't practice criminal law. I don't practice criminal law in Wisconsin. Let's get that out of the way right now. The way I read that sentence is he has to do 9 months, but he has 45 days to report. And then he's got a period of probation where he's got to do stuff for substance abuse and sexual addiction and all sorts of other stuff. It's not the worst. It's not as much as I would like. The key to me is this guy's got to do some time incarcerated. 9 months is not nothing. Because she kept talking about, oh, well, he needs to do all this stuff for treatment. And I'm thinking, yeah, which is what she did. But I'm thinking, yeah, but he doesn't have sufficient motivation to treat unless you have consequences. He needs to be incarcerated for a while and come to the realization that maybe I don't want to do this anymore. I don't know if that'll happen, but but for two reasons, both for his rehabilitation and also for the safety of the public. But that's what happened. I don't understand why he gets 45 days to report. But there may be reasons for that from prior hearings or something. I'm guessing, I don't know. I'm guessing the wife has been in before, and he's got a bunch of kids and all that kind of stuff. So they're giving him time to get his affairs in order. Also, I think that the victim here probably was discouraged by the wife from showing up and making things worse. But all that is speculation on my part. In short, I know nothing. You saw the same hearing I did. Unless you practice criminal law in Wisconsin, you probably don't know any more than I do. I'm happy you got some time. We need some consequence with this. The rest of this is just, how do we, make this guy feel better? It's like I'm all for rehabilitation, but we gotta have some consequences paired with the rehabilitation, or you don't have sufficient motivation to do anything. And I think we have some of that here. I would have liked to have seen more, but I don't know the magic number. I really don't. So there you have it. I told you right on the thumbnail. This is a creepy deal. It definitely got worse. Thank y'all for coming out. I appreciate it. I'll see y'all soon.